We have given what?
Beyond what we have in the court on that.
No, with respect. Half of them are procedural, timelines, etc. The balance is substantive. Give me a counter suggestion. Give me a counter if you are not satisfied with this.
We have to read it. I am expressing.
No, I appreciate.
So tell each one of the words where it is going beyond what has happened.
Yes, I appreciate.
Not look nice.
It may be possible that there is something more or less. They can sit with us and decide. I have no problem. I'm not saying this is gospel truth.
You are not following it in true sense.
I'll tell you why I'm following it, but that can come. I can sit. They are not prepared to sit with me. I'll tell you why it's correct. I hear Justice Bharati's point very clearly. I'm just responding.
Can you agree on the terms of reference to the arbitrator?
We are prepared to. Well, what more can I do? I give you a proposal. You sit with me tomorrow. I may agree. We'll be up and down a little bit.
Whatever disputes are there in the suit or are likely to arise, irrespective of the limitation and all that, sit together and get it resolved.
I am not giving any per se answer to your Lordship Justice Bharati question. I will sit with them. If it doesn't work, it doesn't work, but it may work. I agree with my lords. I am not saying that this is
if you are not agreeable for arbitration, then of course we have to decide whether the amendment has rightly been allowed or not. Then again 30 years you will be spending in the litigation.
My lords have perception about something which I am very happy to do up and down depending on what they say. They say nothing. What do I do, Malas?
Cannot also be through simple arbitration. Portion method, mediation, and finally it should come before it's implemented.
Well, last time, if your Lordship recollects, arbitration was thought to be the better mode to start off. But if your Lordship thinks that you have pre-arbitration mediation, I will even go for that, Malas. There is not a contradiction between the two. In case
so Kumar, supposing, all right. But one question. See, they have given you these proposed terms of reference. Probably they may not suit you. You are not agreeable to it. But can both of you sit together and work out the terms of reference?
Due respect,
terms of reference or mediation, whatever it may be.
All humility, I say, my instruction is that we cannot have an arbitration in this matter. Why we can't have this arbitration in this matter? Kindly come to page 79 of the paper book which my friend is fine.
Yes.
And there is no dispute on this. The minutes of 18/12/1995. The original is at 78. At 79 is the type copy.
Yes. Which clause?
This is
A.
BPCL is the sole owner of 839.67 area of land at such and such which has been acquired or allotted to them by government of Gujarat for making their marketing terminal to evacuate products of my learned friend. RPM is having no right, title, and interest there too. RPM is not enter upon carry out any activity on the said land without written authority from BPCL. If they have done any activities on such land, BPCL will be entitled to remove the same in any manner whatsoever at the cost of RPL. With BPCL will protect this land by fencing compounding wall.
Next para.
Yes.
Also. The land has been charged for the building a marketing terminal at such and such. So I read this is also written in the first para.
Right, complete.
My friend's company, if BPCL does not make this terminal either directly approved the joint venture, it shall transfer this piece of land subject to necessary approval at a mutually agreed price to the company which will own and operate the marketing terminal. Now they start encroaching from 1994 itself. My suit was filed in 95 for what purpose? Because they were encroaching on my land. Today, my lord, the satellite imagery, they may not do adjournments of 80 times for the purpose that not even the surveyor could be appointed. And only a surveyor could be appointed in 2023. In 2024, the report has come by satellite. They have taken over all the 829 acres of land. Entire land is taken by them. So, my lord, what am I supposed to do? When 2024 this report comes, I file an amendment application. That is what has been allowed today. So today, my lord, to seek arbitration of something like this, which is my land, not it is a public sector corporation.
We understand your anxiety.
if all that we were required to do. So therefore, they are not even allowed to build that.
No, well,
And therefore, not, based on this, there was an injunction order passed on the very next page, at page 81. Based on this consent term, page 81.
Yes.
My order 59-1. Her direct advocates at the counsel for the defendant, that is my friend, has filed this application which bears the signature of authorized officer,
Merits.
namely so and so under this. The Xerox copy of the compromise is produced. Application does not now require to be decided on merit, hence disposed of.
well,
Sorry, Bharat. So that's something.
don't give multiple things. You are at something else, I have heard something else. Don't give it to us. Give me a non-money pages. Write it here. It seems. Write it here. Add here. Well, as one sentence, it's very interesting and ironical. When a friend talks about oil, the last para says that you will have this land if you build a thing which can evacuate my refinery products. You don't reciprocally do your part. You claim the first two paras. I file a suit where all this is there. The whole suit will be transferred to the arbitrator. It includes the aforesaid will be at a mutually agreed price. The arbitrator will decide all this. What's the point of us prejudicing you here today? If you are absolutely against any settlement by way of arbitration.
No. Yes, I have taken over the land.
No. So in short, you accept that some part of the land has been taken over by them. Now, can you? All right. We understand. But can you cover it without going through the civil suit or proceedings? That will take time. Now, alternative would be that you settle the matter or you ask for the adequate compensation for that. See, probably what I understand is under this minutes, you are the owner of this land. It has been allotted to you. Now you have to build a terminal.
They should vacate the land. I will build. I don't why
Yes.
vacate. They agree with my land. They will not vacate the land. I am capable of doing it. I am a
We take the situation as on date. See, today, right.
Company, whatever. I am doing well. I can do it. I have the land. Yeah, I paid the money. Cost of it. By what? I paid money for it. And without today, it's the best. They forget the land. I built the terminal. They use the terminal. I will evacuate the goods.
No, settlement is not like this. See, today.
Once you agree that it is my land, why not you take?
While a settlement requires some mediation first. You can't have it across the bar. You have to go through a mediator.
I
and then
was
through an
suggesting
arbitration.
something different.
Not so simple, Miles.
You are the allottee of the land.
They may not.
Yes. You are the owner. You have been allotted this land. You are the owner. Now, some land has been encroached by the other side. You are supposed to build a terminal.
Yes.
When you fail to do it, probably they can do so. Maybe. We are not going into that. No.
We put blood, linger on.
Today we are not going into that, but this can be gone through by the arbitrator.
That's all they should.
Or in mediation also, if both the parties are willing.
Board, not this matter has only got to go to the board. I have no instructions today to agree to any arbitration or mediation. Let me put it frankly to you.
Because one of the conditions says that it can also be transferred to this RPL. One of the conditions of the minutes is that it can be, it gives. So now if
At a mutually
very
agreed
big
price.
if- now if today they are in possession, you can part with the land on some compensation. That can be one way of settling it.
Maybe, but I don't know how much, maybe 10,000 crores or more.
Take it.
People will not, and the lordship know.
Now, let's stick to the main. Let's stick to the case, Bharat. Let's stick to the case. Who is more powerful than a Maxi Ratna? Bharat?
So we know we are very powerful. We can do whatever
No,
is legally permissible within the law.
within the law.
So the suggestion had come only for that reason, because you have already spent, both of you, 30 years with no result. So we wanted a settlement.
This, according to my instruction, this has all happened because of their delay. And they kept on postponing their survey of this.
Accepting.
23 order was passed and 24 survey came. And after the survey, I moved this third amendment application.
Mr. Ranjit Kumar, we are not disputing.
That doesn't still answer why we can't go to arbitration or mediation.
Or to some extent, you may be also responsible for the delay, but that is not the question. No. We are accepting what you are saying. But the only thing is, whether you want to linger on this litigation for another 25 years or 30 years, or would you like to settle it down?
Suit may be expedited, let the suit be decided.
So he doesn't want either mediation nor pre-arbitration mediation nor arbitration is what he's saying.
Arbitration, he said, he has instructions not to go for arbitration.
We are talking of pre-arbitration mediation.
Pre-arbitration mediation.
And what your lordships are putting to me is paragraph 3 of this minutes. On that,
Probably, if I am not wrong, then we also requested that you take instructions and suggest a name of some arbitrator or whatever, mediator. We will appoint some retired Supreme Court judge or somebody.
What your lordships record in the order of 16th March is Mr. Subramaniam, Learned Counsel,
Yes,
said that he would take instructions as he has already suggested to such a measure. That's all. He has suggested, the company has not accepted. But your lordships order record this.
Correct.
And we see the second last paragraph.
That's right.
He would take instructions as he has suggested. But the suggestion came from him. That suggestion has not been accepted. Either your lordships
That
want
means-
this immediately here,
No. Whosoever. It hardly makes any difference.
to say that we are not agreeable to plot this regarding mediation as it falls from your lordship because of paragraph 3 of the minutes of the meeting. We can still take this as.
Not saying anything. We are not saying anything to any party. What is before us is a simple order, 6 Rule 17 petition. You have your case, he has his case. Please, yes, at a particular date we will hear it. Yes, let it not. No, see, when you are addressing us, I did not disturb you at all. Because we can't also, in 60 matters we raise our voice, by the time we go home we will get tired and gone. But whereas you people enter in a charged atmosphere, attack us and go away.
No, it is a very small matter whether the amendment should be allowed or not. For us, we had no difficulty in adjudicating. But looking to the past history of 30 years,
1 second. If
now we fix for the hearing, but in the meantime, if you want to seek instructions regarding mediation,
Very well.
and if that is possible, you can do that also.
Let us keep the record clean. None of the things we are suggesting. This has come as part of deliberation and as part of the argumentative effort by the council. We are not asking parties to terminate litigation in one way or the other or get engaged in a procrastinated litigation. We are not saying it to either of the parties. One is Navaratna, you say another is equally influential. They will work out their remedies in accordance with law. What is falling is, this is an option. We are on our own not suggesting anything to anyone. Now, is the record clean? Is the record clean? And we are not suggesting that any advocate appears in this matter. Let that also be clear. For us, either Dr. Singhvi in this matter stands this side or in the matter he stands this side, it does not make any difference to us. Yes. At least 1 second. Concluding sentence. I and my brother will be very calm. Calmness does not mean that these things can influence us. No. We are calm but very firm.
Because the Lordship referred to a submission made by Mr. Subramaniam. Therefore, my Lord, I. Only because
Mr. Ranjit Kumar, 1 second. With the little memory I have, each frame I can reconstruct in the court what happened that day. With little, I may not be very deep rooted in it.
Went on for a while. Your Lordship
For your
knows
benefit,
what-
my brother is repeating.
I can recap the each scene. So
what your Lordships are saying, right?
we are saying, let the record be clear. Nothing is falling from the
Fair enough,
bench.
that's fair enough.
It is adjourned. Mediation is your discretion.
In the first week of May, Lordship may keep it for final hearing. And Lord, in the meantime.
No, it's not. We have not even gone that far. We have not even gone that far. After Dr. Singhvi argues, we may not be in agreement with him. Why do you want hearing? No, why do you want hearing?
Miscellaneous, not all that.
No. But if you are saying that this is a matter for admission and hearing, we will do it.
I'm only saying non-miscellaneous.
We'll give.
Nothing else, you know.
Dr. Singhvi himself knew that where I stand in this matter, I know, my lord, this is against an interlocutory application. He began with these words. But I have without prejudice to my rights, I have a submission to make. That is how he began the matter.
So, Lordship may fix any date. And Lord, in the meantime, we will try to create.
Ranjit Kumar, the counsel. The respondent is stated, instructed arbitration in the not suggesting any via media a party to resolve the dispute. The matter simply arises out of occasion for moved in civil 5/5 of 19.
That now it was has
Now,
become
now number
Renumbered.
civil suit for 182 of
one,
2000.
now special
Renumbered.
renumbered as a special civil suit 180
of 2010.
10. So the adjudicator of controversy involved therein. However, even if the parties that is guilty of a plain instruction,
Lordship
Sir.
said that they may explore.
they may
That's what. In the meantime.
yes, the petition in the first week of May,
They did not.
as agreed by the parties in the first week of May.
7th, would my 7th May suit, my lords and my learned friend? 7th May.
Thursday is a hearing day, Dr. Singhvi.
No, Thursday. Put it on any Monday, Friday, I have no problem.
You can put it on.
Tuesday.
No, then Friday is 8th or 11th.
We can have it on 12th, but
12th is a Tuesday.
12th May.
Lordship.
But on Tuesday we have
Lordship.
12th. Whatever, 11th May, 12th May, whatever lordship likes.
So 11th is again.
12th is all right. 12th is all right.
the 12th whatever suits.
Your lordship is
12th May.
obliged. Me, sir.
Monday, sometimes can get problem.
Agreed.
Ask for a Passover. Your Lordship normally says.
No, whatever is convenient. One day makes no difference to us.
12th, obliged.
12th.